this. There are uh, two criminal statutes that looked at um, uh, school at disruptive school discipline behaviors. The criminal statutes, penalized, what they were terming disruptive school discipline behaviors. And the South Carolina court found that both criminal statutes were unconstitutionally vague as they applied to elementary and secondary school students. And as we looked over the ruling, we realized that many of the challenges the court raised with respect to the criminal statutes are similar issues that come up when we look at state school discipline statutes. Child Trends has spent the last few years in a couple of different roles looking at state school health policies, including statutes and regulations, and that includes state school discipline statutes. And I also want to be clear here. In this piece, we are not saying anything about the implications of the court ruling, because it was focused on criminal statutes, for the constitutionality of state school discipline statutes. We are not a legal entity, so we are not trying to make an argument that the South Carolina judge's ruling has any direct bearing on school discipline codes. However, the argument that led them to determine that these two criminal statutes were vague, we thought presented a really powerful analysis that, when applied to school discipline statutes, should lead most people to the conclusion that the language that we are using in state school discipline policies is patently unfair and creates risk to children in our schools and places, particularly children of color and children with disabilities, at disproportionate risk of school exclusion. So, and yes, Harold, this is absolutely an ACLU case, and I'll also say I'm aware, like just before we published the piece, the ruling has since been appealed. So and forgive me, I've not been following the case like that that closely, but we'll see where the appeal goes. Still, we found the analysis that the court used be really helpful in explaining to schools why they should really be considering a different approach when it comes to discipline policy. All right, so there are different parts to our analysis. The first part is, to what extent do state school discipline policies have within them language that might fail to clarify for students what the prohibited conduct is? And we've seen some of this in school discipline research before. In California said you can't suspend kids for willful defiance or insubordination. That was done based on research that showed that children of color in particular are removed from schools at rates significantly higher than their peers, based off of such language, and that this language really does seem to open the door to subjective interpretation and subjective enforcement of discipline policy. So we looked across state school discipline statutes and simply tried to answer the question of how widespread is the use of vague language to describe prohibited conduct. So the first thing we found is there's a wide range of terms, that could be considered subjective. So disruptive, willful, willfully, different variations of disobedient, disorder, defiance, unruly, insubordinate, disrespect, disturbed, non-compliant, malicious, noisy, uncontrollable. In all of these, a reasonable person might be able to, make an argument around one or two of these, whether or not they're clear or not. But there are many of these that where I think there would be, just a lot of contention about what is meant. And I think it's pretty easy when we're talking about, young people. Um, have we provided to them a clear standard for what should be guiding their behavior? And I think in many cases the answer is no when we talk about disruption. So looking across, these terms, we found that just about all states had, some variation of these terms somewhere in their state regulations and or statutes. 48 states, and we found 156 different types of discipline policy across 48 states and District of Columbia that relied on this language, with the most frequently used terms being some version of disruption, some version of willfully, some version of disobedience. Um, so then we tried to figure out, if they're going to use that vague terminology, do they provide any kind of mechanism that might help explain further what is expected of the student? Do they give school districts direction about, to further define? Does the state itself provide, any further definition of the terms? Or you know, do they provide any additional context that might provide a more consistent standard for enforcing um, for enforcing the policy? Um, and we found that to some extent, states did this in one way or another. So 32 states do require districts to identify the specific behavioral misconduct that's being prohibited. But oftentimes it's not like that language would go far. It basically is a requirement that they develop a student handbook, or you have to develop a code of conduct that further defines the policy in the state statute. In half of those 32 states, the policies do include some kind of definition of the vague terminology. So if they use disruption, they provided a definition of disruption. If they used um, defiance, they included a definition of defiance. And then we did find that in 33 states in DC, there was content in the statute that defined the scope of the policy by saying, here is the time period that the policy applies, and here's the specific space and location where the policy applies. That said, we found, relatively few states did all three things. Few states, gave the direction to districts, included definitions in their policy, and specified the where and when. So, for just those three, only 14 states did all three of those things. The last thing we did, just to close out the piece, was try to extract from the court ruling from the South Carolina court's analysis, just we tried to extract, their assessment of what would have made the criminal statutes constitutional, and use that to provide recommendations on how state school discipline statutes could be more fair. And again, the two are not on the same ground legally, but we thought they would still provide a helpful, provide helpful guardrails, for state policymakers. So first and most, most obvious is, don't use the vague language, and wherever it is used, you do have to enumerate the specific prohibited behaviors for students. And by specific, it needs to be specific so that, even a child would understand exactly what it is they can and cannot do, and that any adult, two reasonable adults would understand what what conduct is allowable and what conduct is prohibited. Aside from the prohibited conduct being clear, the prohibited conduct should still be distinguishable from from child and adolescent conduct that is developmentally appropriate. So, even if we can get to a point where we all understand what noisy is, there is an age where children are noisy, and that's normal. They do need to establish, where and when the policy applies. Again, trying to make sure that there is, not just clarity for students, but a clear enforcement standard for adults. So, is it during school hours? Is it during, school activities, et cetera, and so forth. One, piece that came from the ruling was, actually, I'll speak to these together. Two pieces that the court spoke to was, accounting for the student's knowledge or intent of wrongdoing, and accounting for the outcome of students' behavior. So it's not, if you're going to say it's disruptive, you need to be clearer about what the actual disruption consists of. Like, what if you're going to punish behavior that results in a disruption, like how is it actually disruptive? Like, can you detail, like, what was the actual cost to a school environment? It needs to be tangible and concrete, not, somebody was yelling in the hallway and it doesn't bother anybody. Did it disrupt instruction, somehow? Were other students actually inhibited from, the work of learning, and teachers inhibited from the work of teaching? The outcome of the student's behavior needs to be clear, and the policy can somehow account for the student's knowledge or the intent of their wrongdoing. So I'm going to stop there, because there's a lot to unpack. And of course, Harold, as this, we did this in response to an ACLU lawsuit. Of course, welcome your thoughts and questions as well.
If I can just give an immediate reflection, let me turn my camera off because my signal is going in and out. But I just want Kristen, one of the reasons why I appreciate this research so much is because for years, obviously, people who are advocates have been calling out systemic racism, oppression, gender bias, et cetera, in our education systems, talking about the school to prison pipeline. And I feel like what this child trends analysis has done is given people like that, I will include myself in that category, some armor, some tools in our arsenal. I mean, that indeed is what data are. And so it's really helpful to just really see such a comprehensive review of what is happening across states.
I mean, yeah, that's exactly what we hoped to be able to do, I think. So the research has just been clear about the influence of these subjectively defined behaviors, but what's not been as obvious is just the extent of the subjectivity in policy. And one, really important limitation on this research is that students are generally subjected to discipline pursuant to local codes of student conduct, right? The state typically just provides, the guardrails, and then school districts design codes of student conduct based on those. So to some extent, we still don't have, the full extent of, how widespread the use of this type of language is, because this is just state level, it's not at the district level. But if it's at the state level to this extent, that's pretty that's a significant red flag.
I'll say I find this really promising in that I think it moves us forward to making those categories of disruption more specific, as you're describing, like exactly what was the conduct and what was the consequence of the conduct. Because when we're doing an analysis of, particularly disparities in racial disparities in school conduct, we have, this large category of disruptive behavior, and we find there's a lot more kids of color being suspended in this disruptive behavior category, where it's almost like missing data, because we don't know exactly what it was that happened that led to the discipline or the exclusion under that vague category that doesn't really describe the behavior. And so moving forward to saying, like, you must be specific about what the infraction was or what the prohibited behavior was, will really allow us a better insight into, how racial disparities are coming into suspensions and, how to address those. I think it's a major step forward.
This is also one of those areas that, I had a chance to speak with lawmakers just a few weeks ago, that asked about, what are the implications for safety, if you remove, if you don't allow schools to remove for subjectively defined offenses, because you'll often get, concerns that, this is a necessary tool. We have to give schools, full flexibility for them to decide when a child needs to be removed, and that is in the best interest of school safety. But because, this language is so subjective, it captures such a broad range of behaviors, it's really difficult to argue that either way. It's just this black box, right? What we suspect is that these are very low level, offenses, and that if it was, if we were talking about, behaviors that were more dangerous or more severe, they would have been put in a different category to begin with. But it's difficult to have a conversation about, I'll say it's not difficult for me to argue that removing suspensions for these, really doesn't represent a risk, to safety. Because, I know forgive me, I'm gonna say the exact same thing I told lawmakers a few weeks ago. Like, I know what fighting is. You bring a weapon to school. I know what bringing a weapon to school is. I trust any teacher. I trust any, administrator to be able to recognize those behaviors and, enforce them, in a way that's equitable. At least strictly based off the letter of the law, biases aside. I have no idea how an adult, any, reasonable, rational adult is supposed to distinguish, what a disturbance is from what a normal adolescent behavior is, the way that these are described.
A follow-up question, Kristen. So one of the things we were talking about recently for our policy agenda is obviously we need to narrow down that level of subjective infractions and discretion that's being allowed in the school building, but also for those instances where it is allowed, creating some sort of checklist or protocol that folks in the building administrators have to abide by to say, yes, this incident, this occasion called for an element of subjectivity. Just wondering your thoughts on that, and if there are any states or jurisdictions doing something similar.
Are you saying a checklist that happens at the level of an incident as opposed to at the level of policy?
I guess it could be both. I mean, it would need to be within policy that it's required, right? I'm just trying to think about how we apply objectivity to the subjectivity so that we're
Yeah,
sure that if we're allowing some element of it in the school building, that it's still being done in a way that can eliminate bias as much as possible.
I would say the if anything, it seems like you would apply the checklist at the level of policy and perhaps training, right? And the question is, this double-sided coin of which I really saw as the guidepost on, how the court approached the South Carolina case. One side of the coin is clarity to students about the prohibited conduct, and the other side of the coin is, clarity to the adults on how to enforce, right? Looking through a piece of policy itself, you know, we should be able, the checklist should be for, you know, vulnerabilities to subjective interpretation in the policy itself, and then perhaps, safeguards that promote objective interpretation, perhaps at the level of training. Um, I don't know. I'd have to think more about how would you approach it at the level of an incident. Um, I mean, I could see, account for the outcome of students' behavior. I could absolutely see though some subjectivity that comes in, the outcome of students at the outcome of a student's behavior. Um, Simply saying that there actually, has to be a concrete, tangible, you know, co- you know, um, there has to be a negative consequence. If you're going to punish a student for this, their conduct had to result in something negative for the environment. Um, but I guess I could absolutely see some subjective interpretation in that.
I think we have a couple of folks with their hands up. Kate, would you like to ask a question?
Kate, you're muted.
Sorry about that. I was just wondering, is there a state where the legislation or the statute for school discipline could act as a model for other states? Is there anybody that's doing it right?
So I can't answer the question about whether or not there are states doing it right. I
Right.
can answer the question of whether or not there's states working hard.
Okay.
So Colorado's been working hard. California has been working hard. Off the top of my head, I think those are top two. In recent years, I've seen quite a bit out of, I know Washington took a really comprehensive approach that didn't just focus on school discipline policy, but also thought about the supports that in the conditions for creating education equity. And so discipline they saw as one pillar of that effort. Then you have places like Massachusetts, again, probably not a strong policy example, at least not a strong discipline policy example, but they've chosen to approach this from the standpoint of trauma and have tried to think through, using grants to promote more trauma sensitive school environments.
Yeah, I've seen that the Massachusetts ones. I work with kids in the foster care system, so almost all of our kids experience trauma. And just from my personal experience, I see that as maybe even, I don't know if it's more so, but one of the major issues is just the school system's not misunderstanding of trauma. and how it impacts learning and what behaviors look like when kids are traumatized. And so you see kids having trauma reactions and being disciplined for it, which only makes it worse.
We released a few years back, this was before states like really started pushing on school trauma statutes and regs. We did a policy framework on this. I'd be happy to share it. When it comes to trauma, we've seen some really interesting, promising approaches in state policy. We've also seen a couple directions that were a little scary. You know, the field really reacted strongly to research on adverse childhood experiences. The study of the 8 original different forms of childhood adversity, and the research that linked experiencing ACEs to future negative health and academic outcomes. The problem we saw as folks were trying to figure out a good policy response to that is that they would often try to take those 8, ACEs, make them into a survey and simply want to ask kids, have you experienced any of these? And if they say yes, they say, okay, you're the ones we have to give, intervention and treatment to, which is 100% wrong. It's just it's completely, wildly, totally, please don't do that wrong. They would try to search and destroy the ACEs. And it just doesn't, child health doesn't work that way. More important is trying to create, as you said, Kate, a system that is welcoming of children that have experienced trauma, that has a fundamentally different response to child behavior, rather than trying to identify the kids that have experienced trauma and trying to, get them supports at the risk of stigma and other challenges. Am I calling on people? Who's calling?
Go right ahead if you'd like.
Marcia.
Thank you. I really appreciate what you've said and everything. I guess I'm still so cynical. When we describe disruptive, even if you say the when and the where, I think that and I'll just use this as an example. There's 2 guys walking down the hallway and they get laughing and joking between class or during a class time. They're going somewhere. They get laughing. One gets bounced off the lockers and they continue on. If they're 2 white guys, then the voices are different than if they're 2 black boys. And so I just see how that can still be subjective. It's somebody is tuned in on that. And I just, this might help. It might be a start, but I'm concerned that I guess it's better than a sharp stick, but I'm just concerned that it's not really going to address the problem of racism and bias.
Yeah, I can see where I can see some vulnerabilities in it. I'm not gonna say that what we identified is perfect. And I think some of the examples that were provided in the ruling really help
Okay.
illustrate how this could work.
Mm-hmm.
And so one thing to think about might be that any de minimis cost to learning or teaching is not adequate, right? So it's like, is there a way to illustrate a cost to the learning environment that is significant, substantial, as opposed to people just saying, oh yeah, like they disrupted my lesson.
Mm-hmm.
which could be quite vulnerable to interpretation. right?
Right, right. Did you also mention, I have one quick question. Did you mention where Pennsylvania fell in that list? You mentioned 32 states do this and 16 more do that. And I was just wondering, does Pennsylvania fall in there anywhere?
I don't remember off the top of my head. My co-author would know,
Okay,
but unfortunately I don't remember off the top of my head.
that's okay. Thank you.
Harold?
So it actually is, if you click on the link to the report, it is, Pennsylvania is on a chart there. And the child trends, if you look at the child and just click on it.
So we have the chart shows you which states have each type of have the language, but what we didn't show you is, you know, for the states that actually defined, right, like that part's not in there, like which states, you know, either directed districts to further define or define themselves, or, you know, specified in the statute, you know, date and time. I don't think we had those pieces in the brief. I could be wrong.
So I just, tell me if it works. I tried to attach the copy of the ruling from South Carolina in the chat as a PDF. Tell me if you can access it, but that gives you the actual language. Oh, well, that too. So, well, yes. I had a couple of things to say. I mean, I generally look at, when I look at this whole issue of sort of vague language in school codes and in state laws, you know, there's some states where the state is more prescriptive and there are other ones where the state is more permissive. In other words, permissive being, it says that, you know, school districts have the authority to take whatever measures they need to in order to keep schools running, you know, in a with sort of good order, and et cetera. And, you know, and that's where the disruption language comes in, whereas other states set it up as a particular category of exclusion. So Pennsylvania is more in the permissive end of it. It says, hey, you school districts have the power to make whatever rules you need to make in order to keep schools running efficiently and effectively. And you can create whatever discipline policies you need within certain parameters. I mean, the parameters in Pennsylvania law are principally around the length of time that a student can be removed from school and the due process that's associated with that. So, and there's a certain due process that's triggered by more than 3 days, but less than 10. And there's a more formal process if it's more than 10 consecutive days. And so that's sort of the framework. It kind of punts the issue in terms of how to define these issues in school codes. It punts that to school districts. Back in 2016, the state legislature, and this was actually pushed for by a then Republican member of the House, had the state's Joint State Government Commission, which is a research branch of the Pennsylvania Congress. They do research studies for Congress. They literally have an office in the Pennsylvania Capitol. They were commissioned by the legislature to do a 1-year study of school discipline policies and practices in Pennsylvania. Now, I was involved with this process. Anyhow, at the end of 1 year, they came out with a report that made a whole bunch of recommendations for change, including in part on this point. And one of the things that they pointed out in the study, which looked at a bunch of central Pennsylvania districts in great detail, is that school districts meant very different things by zero tolerance in terms of what's a zero tolerance offense. I mean, they're dramatically different, you know, in terms of the severity of the behavior that could trigger a sort of a, you know, an invocation of the sort of zero tolerance policy in Pennsylvania, which is essentially a policy of saying when expulsion is mandatory in Pennsylvania laws, the way it works. And the commission recommended, the committee that approved the commission's report recommended a bunch of changes in Pennsylvania law, none of which were ever implemented. But they pointed to a problem there with the fact that school codes are written so differently that something that wouldn't even be, you know, an offense under some codes would be zero tolerance in another. And it looked at about 19 or 20 central Pennsylvania districts. I'll put in a link to that. And, you know, so there are a bunch of different issues here. And what we've done in Pennsylvania is to sort of fight this on a district by district level. In Pennsylvania, and actually I have a meeting about this next week with school district lawyers in Philadelphia, we've really fought to you know, shrink the whole general category of disruption and to in favor of you know, specifying which specific behaviors require what type of intervention. And I know there's an ongoing struggle in Pittsburgh where Pittsburgh has a particular problem with the overuse of disorderly conduct, which in the school code. And in fact, the state auditor, I'm going to stop talking about this in just a minute, but the state auditor general called out, you folks are in Pittsburgh, so I'm going to tell you, about 5 years ago, the state auditor general specifically called out Pittsburgh Public Schools for having an unusually large number of incidents that were categorized as disorderly conduct. Something like a third or more of the ones in the state of, let's say there are 500 districts in Pennsylvania, about a third of the disorderly conduct incidents reported to the Pennsylvania Department of Education came from that one district. So back in, I think it was about 2015, there was actually a conversation on the school board about whether the administrative charge, not a criminal charge, of disorderly conduct was being dramatically overused in Pittsburgh. And it's still a struggle. The district and the police and others, you know, have been pushing to keep disorderly conduct language at that level of generality in the school code. And we've been fighting with them about that issue, showing that it basically is a racialized form of discipline. So I'm sorry, I had a lot of things to say there, but the legislature took this up. They commissioned a study. The study recommends changes in Pennsylvania law and school district practice. None of those things were ever implemented. So there's struggles going on around the state about who ends up in these categories, which types of kids end up in these sort of categories of general categories such as disorderly conduct, disruption, and Erie was openly lewd behavior was one of those general categories. Anyhow, that's my take on it, sorry.
Andrea had her hand up.
Hi, yes, good afternoon. I was wondering if you could clarify some information that I think I may have missed a bit on like, because I do research in this area. So I'm an assistant professor at the University of Tennessee in social work. And I was curious to hear more about what you were saying about ACEs and about ACEs. So you were like saying something to the extent of schools were like, oh, here are the kids with the ACEs. So like, let's try to like do
Search and destroy the ACEs. Search and destroy the ACEs.
Search and right. So is it like, is that more so about destroying the data that, you know, and like, could you explain that a bit more?
No, I have to. I tried to keep it short because I didn't want to go off on a tangent, but no, I'm happy to explain. And before I jump in, I did want to welcome my colleague and the actually first author on the piece, Heather Steed. You want to introduce yourself quickly, Heather?
Hi, everyone. I'm Heather Steed. Thank you so much for inviting us to join you today. And so sorry I'm joining a bit late. It sounds like I've missed some really good discussion.
Sorry, I was finishing up another note in the chat. So for ACEs, so here's the problem. There is a difference between adverse childhood experiences, ACEs, childhood adversity, and trauma. Those are three different things. What we want to do is support children with trauma. Adverse childhood experiences are no more than a group of 8 different kinds of childhood adversity that were, established, and there's a well-known study, decades back. However, those 8 categories miss a wide range of childhood adversities, particularly adversities disproportionately experienced by children of color. It includes witnessing and experiencing violence. It includes parental incarceration. It includes having a parent or an adult in your home environment that has a mental illness, but it doesn't include homelessness. It doesn't include, a refugees, experience. I think some people will try to include on the original ACEs as experiences of racism and discrimination. But that varies from study to study. It's not one of the original 8 ACEs. There's just a whole bunch of things in there that are just not in there that absolutely could cause trauma. So childhood adversity encompasses the wide range of events that could cause trauma. So you first have a problem of, if you go with the original 8 ACEs, you're going to miss events. But secondly, if you have 2 children and they both experience childhood adversity, say, assume for once the same childhood adversity, one will have a traumatic stress response and the other will not. And that's because that family factors, community factors, the availability of different kinds of supports in that child's life have the potential to mitigate the adverse impact. So to simply say, well, you have 2 or 3 ACEs tells you nothing as to whether or not that child is experiencing trauma. Tells you nothing. And by the way, the work of trying to figure out a child's, history of childhood adversity, and the work of trying to figure out whether or not a child has a traumatic stress response is rather delicate work. You go poking around in the child's psyche in the middle of a school day, you can create a problem. We do have to be careful that we're not setting up children to be stigmatized within the school, saying, oh, they have 4 or 5 ACEs. Well, that's it for them. Well, what they're set up to fail. So the work of creating, people, it goes by different names: trauma sensitive school, trauma informed practice, trauma informed systems, has to first, really focus on creating an environment that would be welcoming of children that would come in with all of the hallmarks of the trauma, without having to first figure out, oh, it's you. And it's this in your history that's creating that response. There are folks working on more comprehensive ways of assessing children for actual trauma, because to be honest, like, even in clinical settings, like, ACEs is for public health surveillance. ACEs is not for clinical use. But we are trying to figure out, what is the appropriate way to go, in a pediatrician setting, for example, to, look at, the potential for trauma as part of a more comprehensive assessment of the child's health and mental health. And I know that particularly in California, they have been trying to figure this out as it relates to schools. I'm pretty sure they actually moved full steam ahead trying to use childhood adversity in school environments. One is the focus needs to be on the system. 2, we have to be very careful to distinguish adverse ACEs from childhood adversity from trauma. And the third piece is when you're we really need to think about, the context in which any assessment takes place and the skill set of whoever's conducting the assessment and the cultural responsivity of the tool being used in the assessment. As we're trying to figure out, what are the best places to do this. So I hope that's a more complete answer.
Yeah, no, I thank you for that. I just want to follow up and say, as I think about the report that you and your colleague have put out, and we think about sort of this vague language around behavior and its relationship to these, disparate discipline outcomes, I think also to the way that connects to what we're thinking about in terms of the relationship between children's body trauma and the way that may look like for kids who may be externalizing some of those behaviors, right? And what that might look like at the intersection of race, gender, class, and like exertion of like traumatic, like internalized and exerting behaviors that could get them in further trouble, right? So that the case Peter P. et al. Versus Compton, I'm not sure what's going on with it right now, but when that came out, that lawsuit is basically saying, hey, these kids are disproportionately exposed to ACEs and the school system is pushing them out. And so I can just see that intersection there, that like at these vague school discipline definitions or behavioral definitions, right? We have conduct, right? Super vague, not really doing much. That I can see how children who are externalizing sort of adversities that may be traumatic, that are externalizing as behaviors that could be disruptive or get them in trouble, that, I can see the need to still have some type of surveillance from like clinical social workers, school counselors to be supportive in the school discipline outcomes, reducing school discipline. Because I know in that case that I just explained, they're trying to get ACEs or children's trauma to be defined as fall under childhood, under disability, so that the child can't be suspended for it, right? So I just see the overlay.
Yeah. So the one thing I'll say to that is that IDEA is not providing nearly the protection against school removal that we would hope it would. Right? For a couple of different reasons, right? But the most obvious data point I'd point you to is, the stuff I just listed in the chat, right? So children with disabilities generally twice as likely as their peers to be removed from school. So I think it's typically, 10 to 12% as opposed to, 5-6%, for children nationwide, at least looking at out of school suspension numbers. If you're talking about children of color, let's say boys of color with disabilities, you're now talking about rates of about, over 20%, usually about a quarter. So really, really high. So it literally doubles twice. And then for the children with disabilities that are likely identified with disabilities because of their behavior, because of externalizing behaviors, emotional disturbance, they have the highest rates of out of school suspension. So on the one hand, I don't have a strong or an informed opinion about whether or not children that have experienced trauma should, be, protected under IDEA. But I will say that if they were, that we have good reason to doubt whether or not IDEA would provide them all of the protection that we hope it would be. We would hope it would provide.
Great, thanks. I'm going to put this is just a little shout out, but like a link to a paper that I wrote using the National Children's Health Survey about ACEs and like children's surveillance. So if I'm going to share it to everyone, but if either of you have thoughts on it, I would love to hear anything you have to, say about it. I'll send you my email address as well.
Harold, I see you. Harold, I still see your hand up. I don't know if others, have questions, but Harold, I know you've had your hand up.
I have a question. Can you all hear me?
I forgot to take it down. Sorry.
Oh, okay. Awesome. Go ahead, Maria.
So let's see. So I joined late also, and I'm driving, so I hope I might audio doesn't go in and out. So in the state of Pennsylvania, and I'm going to talk specifically about Pittsburgh Public because, you know, that's the school system that I work in, and that's the one I know best. So we have to submit, like most schools, a comprehensive plan that includes our strategic plan and our, you know, our positive Pbis and MTSS models. And in a lot of schools, particularly public schools that have high Black enrollment, you talked about the culturally unresponsiveness of discipline policies. And I know firsthand that there are schools that have Pbis models that use like leveling systems, you know, to discipline. So they use leveling systems, like they assign children a color, and, you know, like burgundy being the highest color that comes with privileges like special lunches, and purple in one particular school, which is in the Black community, a color that represents royalty. This is the lowest level you can be. So within this, you know, so in this school, children who are assigned purple very subjectively for like getting out of their seat or wearing flip-flops, just things that are very, or, you know, disorderly conduct, their privileges are taken away. And as long as whoever assigns the point system that leads to this leveling system, which still goes on in Pittsburgh Public, has no training and understanding of what kids, like you talked about, how kids experience trauma differently. I think that this could be an origin to look like these Pbis models could be a way to look and dissect the inequity in policies, particularly because they're not uniform across the district. There are a lot of the Pbis models that I'm familiar with, like I said, are in schools that have high Black enrollment, and it seems to be subjectively in schools based on, you know, people who are in charge of student support services. So if you could just maybe comment on your familiarity with Pbis and MTS, because like I said, it's included in part of a district strategic plan and comprehensive plan that has to be approved by the state.
So I do know a thing or two about Pbis and multi-tiered systems of support. And the first thing is that the first thing I wonder as you're describing it is whether or not the folks that are implementing it actually understand what Pbis and MTSS are intended to do. Because number one, a multi-tiered system of support is about a tiered system of support, not a tiering or ranking of children. It's the supports that are supposed to be on tiers, focusing on a universal tier of support, where you provide clear behavioral expectations to all children, all places, all staff. So the very first thing, the heart of MTSS is figuring out and implementing what supports all children get all the time, with that focus on prevention. And it can take many forms. Many schools will try to, you know, look at social emotional learning of some kind, you know, as their, you know, foundational or, you know, tier 1 or universal tier of support. And then after that, for the children that, you know, experience some kind of challenge, you know, with behavior, you consider targeted supports, and if the behaviors are severe enough, intensive supports. But it's the supports that should have that should be, you know, tiered and ranked, not the children. So even the way you're describing it makes me wonder, like, are the folks like actually getting it? The other piece to Pbis is supposed to be a data-driven approach to figuring out like what is actually working for the young people within the school, and figuring, okay, is our universal tier of support working? You know, for the young people that need a little bit more, are the targeted group-based supports that we're implementing working? And so I guess one question I would give you to take back is, you know, for the folks that are proposing to use PBIS or being asked to use or being directed to use PBIS, like what supports are in place to make sure, and I know that, you know, you can laugh at me and make faces at me if you want to, because I'll understand the reason for the faces. It was whether, you know, what is the supports to make sure that schools are implementing PBIS with fidelity, that are actually following what it's intended to do, instead of, you know, using the stickers, or
Yeah,
using
the lanyards,
using the
Yeah.
lanyards and the, you know, the physical trappings so that people see that they're doing something, and that's something they're choosing to call PBIS.
Yeah.
When
Yeah,
it's
you
not.
know, I have never saw this particularly called out. And like we talk about the school codes of conduct, but this particular thing, which is embedded in the strategic plan, I was on a panel who had some, you know, I guess some clout to call this out, but there was not enough push against it. But I'm talking about using this subjective PBIS leveling system to like isolate kids in a community school model, like put them in purple lunch. And you can see it. I mean, it's posted in the school.
What on earth is this? I'm so sorry. I don't know what this is.
To school and say, you know, Kayla
That's
Brown
not
is in purple lunch.
PBIS. No,
Can you believe it? I know. And
that's not PBIS.
It's
I don't know what
unbelievable.
that
It really
is.
is. That's not, but they're calling it PBIS. And that's where I'm saying it has to be some kind of violation. I'm telling you that I was in schools and I went to advocate for a child who was like, you can't have teriyaki. These are poor children. I mean, a lot of them are, but I'm telling you, I'm familiar with this family. And they told the child, you cannot have teriyaki chicken because you're on purple lunch. You get a peanut butter sandwich. It's that bad.
No,
And
I'm sorry.
it's
That's not a
approved.
thing.
Yeah.
No.
So it has to be some way to say, you know what? It's just punitive. You know, and the supports you're talking about, the data, because I look at the state data because I work for the Pennsylvania Department of Education.
Yeah.
The data has no fidelity. It's underreported, and it's just a lot more punitive. And let me say one more thing. Kids are set up to not, you know, for these policies to make it more difficult for them to navigate the school system because of things like bell schedules and even the food they're eating. So we're wiring them to just not even be successful, and then governing them with these inequitable policies. It's a no-win situation for our children.
Yeah, Maria, one thing I will say is that, you know, PBIS is not easy to implement. It's not a simple, you know, program that comes in a box that you can just implement. It's not a program, it's a framework. And it's not an easy framework. A lot of the places, again, you have multiple tiers. It's not like many places that even have the most support in doing this right. It's not like you implement all the pieces at once. The first thing you do is implement the tier 1 universal basis of support. But what many folks will often try to do when they're implementing PBIS is go, you know, we got some kids that need some real help, and they'll jump into the tier 2, tier 3 services, which is the exact opposite of what PBIS is intended to accomplish for you. You know, oftentimes in schools, what we have is an inverted triangle. Oftentimes what you want is the vast majority of school students, you know, need, you know, some level of support, but it's less intensive. And then, you know, a much smaller group of kids need targeted support. And then the smallest group of kids need something really intensive, that one-on-one, you know, type interventions. But what folks will often do is, because that universal tier is not there and it's not prioritized, you end up with, you know, much larger groups of kids needing the targeted and the intensive, because the prevention work hasn't been done. You literally took the public health triangle and you turned it on its head. It doesn't get you anywhere.
Yeah,
But
I hear you. I'm just, and then, you know, in the restorative justice, we've already had like the ABPSI, the American, what is it? The Afro-American Psychology Association come in and do some work there and just say that, you know, restorative justice is not another thing that the Pittsburgh Public Schools brags about implementing with fidelity, but it's not. So we have all these things that are, you know, governing kids, you know, based on, you know, their disorderly conduct and behavior that's not implemented with any kind of adequate training or fidelity. And we see, I see suspension data. You see what we all know, a disproportionate increase in suspensions and expulsions and referrals to alternative education. Alternative education centers are filled with children. Black children.
Yep.
Yeah, thanks, Maria. I always appreciate your perspectives from the time you spend in schools and with families. It's really great to hear, you know, what's reality in the schools. I'm wondering if others have questions. I think it'd still be fine to let's talk about those, but I'd like to kind of move the discussion into a place where what can we do as Gwen's girls here in Pittsburgh and use our advocacy, use our numbers, use the, you know, the talent and the energy that comes to these meetings, and how do we've been thinking a lot about the systems in which Black kids are disproportionately suspended and otherwise excluded, using these vague categories that don't classify what the behavior is, like we're speaking to, and then there's these other systems that are in place that are really ineffective and harmful for school discipline. So I'd just like to open, if people have remaining questions for Kristen, or for Heather, and then if not, can we move on to thinking about kind of actions for us or strategies for us.
I'll throw out an idea for maybe a strategy, and this is probably a little further along than you were thinking right now, Amanda, but it's just the first thing that jumped into my head, because I get so frustrated every time we talk about this, that part of the problem with things not being implemented in fidelity is because people are not adequately trained. None of the adults are trained. We want all the programs to be put on to children instead of adults changing their behaviors and the way that they do things. So I just wonder if somewhere out there's an opportunity, and I don't know where that is, that we influence the amount of training and professional development. Because I know we've hit up against that many, many times, that they're only, let's say, 8 hours a year. What is anyone going to get trained to do well in 8 hours? I have no idea. But I think that's one piece that, you know, like nurses need continuing education, social workers need continuing education. And I don't know, maybe that's not the place to do it, but anyway, I'll just throw that out there.
And I think a partner with that is that the standards are so frequently changing that it's hard to keep up with the training when the code of conduct changes and when discipline strategies change. So frequently it is hard to have staff that are up to date and fully trained with supports, instead of just, this is your 2 hours or whatever this summer, and then do it for the rest of the year, with, you know, really effective and known, you know, research proven like methods for behavior change, and to have those policies, you know, not only on paper, but also being enacted in classrooms. So I'm sorry I missed last week. Did you all talk about the eliminating the disorderly conduct category from the Pittsburgh Public Schools? And if so, what was the, is that still in it, or has there been progress on eliminating it?
I think that's still there. I don't think it's been removed.
From my understanding, it was removed, but maybe someone knows better than me. Harold?
Maybe I'm wrong.
Yeah, I think it was removed last summer, but there are efforts to put it back. in, as I understand it. And then the other place where there's been pushback is around policies that pertain to policing. So there's two separate conversations going on around disorderly conduct. One was removing it from the code of conduct as grounds for removing a kid from school administratively through a school district action. And I think it was taken out of the code of conduct last summer. And there are efforts to put it back in. And then the second is there's been strong push from some district administrators and from the Pittsburgh Police Department, as well as the school district's police department, to make disorderly conduct grounds for mandatory immediate involvement of the police. So if you look at those two together, that just means, okay, maybe we won't suspend as many kids and slap on the label of disorderly conduct, but we may call the police more often, which is kind of like a whack-a-mole thing that you find there. You hit down one thing and another one goes up. And so my conclusion is that the district administration is really not committed to removing disorderly conduct type charges from kids, despite what's in the code of conduct and not in the code of conduct. Hope that makes sense. So there's this long-running dispute about what's in the MOU between the Pittsburgh Public Schools and the police department. Child Trends folks, you're probably not aware of this because it's Pennsylvania specific, but every district, although the law doesn't require districts to have police on site, every district is required to have an MOU with police department, even if they don't have a school police or an SRO arrangement. Pittsburgh has forever, since the beginning of the legal requirement, which was 2010, been out of compliance with that law. And they've negotiated 4 or 5 drafts. And the drafts get better in some ways, but they get worse in others. And so the push is to push disorderly conduct into consider that to be a kind of infraction for which police must be called. The city police must be called. And that's the pushback that comes from some people in police departments in the school district. I hope I'm clear on that. So there's 2 things going on.
I can't imagine, is the police department supportive of this?
Oh, they're pushing it.
Yeah. Oh, they're pushing. They do want this. They're advocating.
Oh, I mean, their position is that we want to know everything that goes on with kids, and then we can decide what things we want to be involved in. That's the position of the police department. They've said it. The lawyer for the city's police department said that in my presence.
Okay.
But I think we should mention, Harold, to Kristen and Heather, that Pbis has its own police that are employees of the school district that are separate from city police.
Right. And they're members of the AFT as well, of the teachers union. So, you know, they're pushing for it, but also the city of Pittsburgh Police Department is pushing for it. And that's the way you end the school to prison pipeline in Pittsburgh. So it's kind of a 2-front struggle there.
Yeah. Yeah.
It sounds to me like if the disorderly category has been removed and there's some push to restore it and even restore it then with a qualifier that the police be called if, I don't know, any staff member finds a student acting disorderly. Because I mean, from my understanding, disorderly can mean refusing to comply. So if a student is in the hallway during class and a teacher says go back to class and the student doesn't, they could be considered disorderly at that point. And I mean, having the thought of escalating by having a police officer show up in that instance seems to be you know, in every way counterproductive. So I wonder if we're then, who's involved in the decision to restore. I mean, it's a school board as usual. I mean, I'm sure, to restore the disorderly conduct to like you're saying, Harold, there's two things, the MOU and then the code of conduct. And I don't know, we've been talking about that MOU for 2 years in this group.
Yeah, I've been talking about that MOU for 4.5 years. So with that, I think it's back to 2017 or something like that.
But I think if we have the information that we have now, I mean, it seems like this always becomes a conversation about trauma when we talk about school discipline, particularly in these lower level infractions that are often defiance or disrespect.
So in Pittsburgh Public, if you look at arrests where kids are charged with disorderly conduct, probably the group of students where that charge is most heavily used is Black girls in Pittsburgh Public Schools. Mm-hmm. That's the part of this that we should sort of highlight here. So in other words, while the numbers are greater for Black boys, the percentages tend to be higher for Black girls. And in Allegheny County, generally, schools are more of a driver for the arrest of Black girls, Black female adolescents, than is the case for any other group of folks, where the arrests are more tilted toward things that happen outside of schools. So there clearly is a disorderly conduct, Black girls, school discipline, administrative practice issue that needs some focus.
Well, I don't know if we should consider a strategy that we've used in the past was like getting together all of the talking points that we would want to say around this, and then sort of flood the next school board meeting to show support for not restoring the disorderly conduct. I know we've been able to get sort of, draw some media attention when we've done things like that in the past, and we have some of those members of the school board who've come to our work group meetings before. I don't know if it's worth reaching out to them to know exactly where that conversation is happening.
So within BGEA, remember there are two of the 4 different working groups are dealing with this. So the juvenile justice people have been juvenile justice working group, which is the one that we at the ACLU, my colleague Gada, who I'm sure you all know, and I participate in, they've been dealing with issues of arrests, but a lot of the other stuff in terms of school administrative, school discipline policy is, a lot of the people who work on that are in this group or in other parts of Black Girl Equity Alliance. So I would think that I would make the simple suggestion, it may be like a joint education, juvenile justice meeting come together specifically around advocacy on school policies, so that you don't have one committee working on it from one angle, another committee working on it from another angle.
This is Mary Hall. I think that would be a really good idea. So can we officially recommend that?
Yeah, I can recommend that to Kathy and to Shira and see how that could be scheduled. We could invite the school board members. We do have some school board members who do attend the meetings. with some regularity. So if that would be a time to have them come and talk about where they are in terms of progress with the MOU, progress with the disorderly conduct, and then we also have in this group specifically interest in advocating around the dress code issues. So if we could raise those and GATA, yeah, for sure. I will send an email after today and ask if we can think about next month's meeting being a combined one, and if we can engage some of the school board folks to be here and, you know, just speak to the Pittsburgh public side. And Tashira had mentioned, you know, PBS is one of many school districts in the county. We end up, I think, focusing our advocacy on them so often because they are the largest group. And hopefully lessons learned from working with them could apply to other districts as well. But yeah, I think that's a good.
Hi, everyone. This is Kathy.
Oh, hi, Kathy.
I'm here. I just joined. I apologize. I had another commitment. But yes, you all actually are in line with some of the things that we've been talking about in a smaller group about combining, or not just focusing on the 4 work groups, but really looking at the issues and the kind of call to actions that we want to focus on, and moving more towards that type of meeting space instead of like it just be separate, because as you all know, a lot of this overlaps. And so this is an area. So I accept the recommendation, and I think that we should start to plan to have a meeting next month that addresses the issues that you all have highlighted.
All, unfortunately, I'm going to have to jump off. It was a pleasure to meet you all, to speak with you. You know, please do feel free to reach out again if you have any research questions or research priorities that you think we should be, you know, building into our work. Take care.
This has been so helpful,
you.
Kristen.
You too. Thank
so much.
you.
Amanda, everybody, one other thing that I'll say that came up, we talked a little bit about, at least the last education meeting I was at, was how to think about pulling in some other districts outside of Pittsburgh Public. And we had played around with the idea of, can we identify, in addition to Pittsburgh Public, 4 other districts that maybe we want to try to think about advocacy within. And I think Harold put in the chat about South Allegheny being a school district, but we did not come up with a strategy for how to identify those. Like, would it be based upon somebody, you know, knows somebody who could get us started in there, or there's a lot of problems happening there and so we should target there? But that might be something for us to revisit at some point too, and think about it. Maybe 5 was too many. I don't know how we settled on that exactly, but just so that we were being inclusive of other districts as well. So I don't know if anyone has thoughts on that.
This is Kathy again. I think it should be a combination of both. What we have done in the past is look at the data and the number of looking at the school districts that had the highest referral rates, for instance, that those are the ones that we targeted. But then there also are school districts that have superintendents and principals that are engaged in the work that we're doing. So, you know, I think that, you know, partnering with them to, you know, make sure and do a deeper dive into their policies and practices because they're open to that, and just supporting a process that leads to change would be helpful. So my suggestion is that we might consider, you know, looking at a combination of both.
Kathy, this is Mary Hall. Do you think we could start with the Pittsburgh Public Schools and then develop a strategy in terms of which other districts should partner with us?
Yep. So let me just tell you, historically or in the past, we've looked at Penn Hills, Woodland Hills, and these are, you know, spaces that, you know, Gwen's girls and a lot of BGEA partners are in and that we have some relationship with. So Penn Hills, Woodland Hills, Clareton, McKeesport. I know Stowe Rocks has come up. Again, these are districts that have issues. East Allegheny. I know that within Harold and Gada's work that they've been doing through the ACLU, their most recent report highlighted South Allegheny as a district that we need to be making contact with. So those are a few just off the top of my head that I know that we probably should reach out to. In the near future, we're going to be pulling additional data to again inform our next steps and see what districts, and even within Pittsburgh Public Schools, it's important for us to maybe look at specific schools that are on the list and not just say Pittsburgh Public in general, but what schools need that additional support.
I would really like to get into South Allegheny first. I feel like there's things going on there right now that are the perfect opening for us to get in there and make change. Pittsburgh Public School absolutely needs our attention as well, but I think with what is going on currently at South Allegheny, there's like this opening that is just begging for us.
And so that's where the beauty of this collaboration. I don't have any connection or knowledge or experience in working with South Allegheny. So they can definitely go on the list, and then we can work with one another to identify a proper way to, get involved with them.
And Kathy, this is Maria. I'm glad you said, for Pittsburgh Public to be school specific, because the EAP always had a less granular approach. We're like looking at the whole system, and there are some schools, and before you came on, I was talking about Pbis models where there are like greater infractions and greater, like the suspensions, some of the models in some schools, that's where the origin of suspension start. So I think it begs for us to take a look at that to really understand what drives suspension and expulsions in some schools, the disproportionality that we see, because we know it's not happening in schools like Colfax that has the same configuration as MLK.
Yep.
Okay, well, do we want to wrap up for today, or are there other issues that folks want to bring up? So Kathy will work on organizing a meeting, work group meeting with some of the school board folks.
Sounds good.
And also the Juvenile Justice Committee.
Yes.
Okay. All right, well, thank you everyone for being here. This was a great discussion today. I'm thankful to Shira for arranging for Child Trends to be here and Kristen to be here. Thanks for engaging in the conversation. Thank you, Heather, for coming. We will see you all next month, and we'll be updating everybody about progress on the next meeting and the content. Thank you.